Let's just start the session. Our expert is here. So, your today's guest lecture is about subscription and share purchase agreement. So, our expert is Advocate Sanaya Parimar. She is Journal Counsel at Pocket Aces Pictures Private Limited, and she has worked at tier law firms like Luthra and Khetan, and in the IPO team of Paytm. She has 9 years of experience in merger and acquisition and media entertainment. She has worked on multiple equity and debt transactions, corporate advisory, and contract management. So, we welcome you, ma'am.
Hi, thank you so much for the introduction. I'll quickly just switch on my camera and then we
Yeah,
can get started.
okay, ma'am.
Hi, everyone. It's a pleasure to be coming here with all of you and to be able to take this class for all of you. So as I just got an introduction, just to quickly tell you once again. So basically, I'm a 2014 pass out from West Bengal NUJS. And I have nearly 9 years of experience. I started my journey as a mergers and acquisitions lawyer at Khetan and Co. After that, I moved on to Luthra and Luthra Law Partners. I was there with Luthra and Luthra Law Partners for nearly 6.5 years in the mergers and acquisitions team, where I worked on a variety of transactions, mostly private equity transactions, along with a lot of advisory on FEMA, Contract Act, labor law, multitude of corporate laws. And then I shifted to Paytm for a brief period of 1 year, wherein I worked on the IPO that happened the last year. And after that, I joined as a general counsel at Pocket Aces. Pocket Aces is the company behind the popular Instagram pages like Filter Copy, Gobble. And we also make a couple of, we have made a couple of shows which have been hosted on Netflix and Disney Hotstar, like Ghar Vapsi, like Amazon, like Little Things. So yeah, in a nutshell, my experience has been mostly on mergers and acquisitions and media and entertainment. And I'm very excited to be taking this class for all of you. As you would have already been informed, the class is essentially on the basics of the investment and how an investment happens, and what are the important aspects of a share purchase agreement and a share subscription agreement. So I mean, how we will be taking this class is that I'll first of all walk you through the basics of investment as to how and why a company needs an investment, and what are the basic steps which are undertaken leading up to the entire documentation stage. Then we will, in today's class, discuss what the basic laws are pertaining to share subscription and share purchase agreement. And once we are done with the basics, then time allows in today. Otherwise, in the next class, we will go through each and every clauses of share purchase and share subscription agreement, and what all should be kept in mind while drafting those. So let's get started now. First of all, I mean, this is a general question for anyone over here. Anyone can answer. What really comes in your mind when someone says a share purchase agreement or a share subscription agreement? Someone is saying "Awaaz nahi aa rahi." Is that the same for everyone?
No, ma'am, you are perfectly audible.
All right. Akshay, maybe you would like to check your microphone. Maybe there's some issue there.
Akshay, join back. Like log out and join back again.
I think a couple of more people are saying that awaaz nahi aa rahi hai. Let me just come closer to the microphone. Is it better for everyone?
Yes, ma'am.
Okay. Yeah. Just one question. Can people answer, or like, is it muted for everyone?
Ma'am, it is muted for everyone. They can use the chat box for questions.
Sure. Okay. Okay, great. So I can see some answers. People are saying SP is purchase of the shares. Share purchase is purchasing share from the existing share of the company. Agreement between the purchaser of shares and the company. Okay. So all of these answers are partly right and partly not. But I'm very glad that most of you do have some idea about what SSA and SPA are. First things first, for the general working of a company of course needs funds, right? And from that perspective, when a company needs a fund, it seeks out in the market. There are private equity markets where people go out and the companies, the promoters go out and seek investments. Similarly, as they say that for a shareholder, like if I'm a shareholder in a company, the shares that I hold in a particular company are my assets. Think of it this way, that you own a land, and if you want liquidity, if you want some money, you may want to go and sell your shares, sell the land that you own and fetch money and then use it for your own personal objectives. Similarly, if a person is a shareholder in a company, since the shares are that particular shareholder's assets, whenever a person needs money or wants to is in need of money, can liquidate the shares by selling it to a third party and can get the money for his or her own use. So essentially, this entire regime of SSA and SPA arises out of two situations. One, when a company needs money, and second, when a shareholder of the company needs money. Now, quickly, let me walk you through as to how an investment, the entire process of seeking investment begins. Let's first talk about when a company needs money. So the typical steps would be that the promoters of the company go out in the market. They basically hire certain investment bankers. Investment bankers go out, find out certain investors who are ready to invest in a company. Now, when there is a perfect match, think of it of a situation where you go to a shop, you want to purchase something, the good that you want, you find in some specific shop, and the price that the shopkeeper is offering is also something that matches your budget. When there's a perfect match, it is exactly when you want to go ahead and do the purchase. So an investment banker does exactly the same thing. Basically, they figure out what is the pricing at which you want to sell. Then they figure out an investor who's ready to purchase the shares at that point. They bring the two on the table. There is a basic document called term sheet that both the parties enter into. This term sheet you can basically assume to be, like a 2 or 3 pager document, where the basic concept of, as you know, what is the price, what are the basic rights that the investor would like to have in the company, all of those are chalked out and entered mentioned into that term sheet. Now, once the term sheet is signed, that is where the process of due diligence begins. Does anyone have an idea as to what a due diligence is? Anyone? Absolutely, it's right. It's a scrutiny. Maybe not a negotiation. Negotiation comes at a later stage. Background check. Absolutely, bang on. This is exactly what due diligence is. As the name suggests, due diligence basically is a process wherein an investor, before investing into a company, would like to go through the old records of the company to see whether the company is worth investing. ऐसे सोचो, like अगर आपको एक land खरीदना है, you are an investor, आप पहले जाके check करते हो, right? Like whether the land is proper, the title of the land is fine or not. There's no fraud committed against you, right? So similarly, if I am an investor, especially when I'm going to invest into an equity shares, the basic premise is that the equity shareholders of a company own a piece of that company. So when you're going to own a piece of the company, you want that company to be as clean as possible. So diligence is a process where the investor goes and checks whether all the licenses and approvals that a company is required to run the business are in place. Like, for example, a shops and establishments license. Every company which has an office is required to have a shops and establishments license. So one of the aspects will be to see whether that company has this license or not. Similarly, all the filings that you're supposed to make with, let's say, RBI or a registrar of companies, whether all of those are made in time or not. Or let's say the company is heavy into entering of contracts, and whether all the contracts are properly signed or not. So the investor essentially goes through these entire processes to see if the company is clean or not. Once the investor is sure that the company is clean, or if it's not clean, then there are certain set of instructions or covenants that the investor will say. Like for example, if the SME license is not there, then the investor will basically include a condition precedent. And don't get boggled by this jargons. When we are going through the SPA, I'll explain each and every term, like what is a CP, what is a CS. I'll walk you through it. But just to give you a glimpse of as to why DD is important, I'm just explaining this entire process to you. So like, for example, if there is a particular license that this company required to run the entire business, that's not there, then investor bolega ki aap ye, before I put the money into your company, aap ye licenses procure karo. So that becomes a condition precedent, which then comes into your share purchase agreement. So in a nutshell, once this process is done, is when the real drafting of the share purchase agreement and share subscription agreement begins. Now, first of all, before we get into what the laws are behind this entire share purchase and share subscription agreement, I think let me first explain to you as to what really is the difference between a share subscription and a share purchase. Once we understand the concept, I think agreement pe hum easily move kar sakte hain. So as the name suggests, share subscription means when a person is issued shares afresh in a company. So ऐसे सोचो that company को पैसा चाहिए. Company, for example, wants to expand its business. Now, of course, for expanding the business, the company would need money. How can the company get the money? So what we do is, like, let's say at this stage, the company has 10 shareholders. Sure, someone has mentioned, could you stick with English? Absolutely, no problem. Right. So basically, the process is such that if the company needs money, what the company would essentially do is that it will seek out to the investors. Investor will come, put in the there is one. Can you also highlight shareholder agreement? Okay, guys. So this particular session is on SSA and SPA. We will move on to SHA after this, which is the later stage. Let's get the basics of the SSA and SPA clear, then we can easily move on to SHA. So coming back, the difference between a share subscription and a share purchase. A share subscription is where, let's say Sanya wants to invest into the company. Sanya will give the money to the company will issue fresh shares. So before the entire transaction happens, the company at this stage has, let's say, 10 shareholders holding 10 shares each. So that makes a total of 100 shares. Now, when Sanya puts in the money in the company, Sanya has issued 10 fresh shares which were not in existence before Sanya invested, which is when the total number of shares that the company will have will become 110. And then Sanya will get issued fresh shares in the company. Versus a share purchase, where let's say a company is holding, a company has 100 shares. Sanya is one of the shareholders. Now, let's say Aman. Let's say Aman wants to invest in the company, and Sanya, who's one of the current shareholders, is in dire need of money. So what Sanya can do is that Sanya can share her existing shares to Aman. Aman can transfer the money to Sanya, not to the company, to Sanya, and Sanya in exchange can transfer her shares that she currently holds in the company to Aman. Now, this is a share purchase transaction. Does anyone have any doubts over here? You can just shoot the questions in the chat box. I think I can just keep answering because this is a very basic of SSA and SPA, the very basic difference. So are we good until here? Sure, I'll explain it again. So think of it this way. I'll just take any 5 random names. There's a company called ABC Limited, and Fatima, Jolly, Neha, Vivek and Sanya hold 10 shares each in the company. Now let's say the company wants more money because it wants to expand its operation. So company finds a new shareholder called Vikrant. Vikrant wants to put in money as well. So Vikrant will come and give money to company. In lieu of this money, company will issue 10 or 12 more shares to Vikrant. Now, after this, the company will have one more shareholder. This is called share subscription. where a new shareholder subscribes to new shares in a company. This is where you draft a share subscription agreement versus the share purchase. As the very name signifies, purchase can only be of an existing stuff, right? So let's say, okay, I'm a bit confused here because some people are saying please explain in Hindi as well. So I'll try to explain the same thing in Hindi again. Let me first complete the thought in English. So as I was explaining, the purchase is when existing shareholder wants to transfer his shares to someone else and gets money in lieu. Now explaining this just in Hindi again. ऐसे सोचो कि कंपनी को पैसा चाहिए और कंपनी ने के एग्जिस्टिंग शेयर होल्डर्स जो हैं उसमें एक और लिस्ट ऐड करी वेयर कंपनी ने बोला क्योंकि विक्रांत हमें पैसा चाहिए, आप हमें पैसा दो, हमारे पास 60 शेयर्स ऑलरेडी हमने 6 शेयर होल्डर्स को दिया हुआ है, हम 10 शेयर्स और आपको देंगे. सो टोटल जो पेड अप कैपिटल कंपनी का हो जाएगा दैट विल बी 70 एंड बदले में विक्रांत विल गेट a new 12 more or 10 more shares in the company. Purchase is where Sanya needs Sanya who's an existing shareholder, उसको चाहिए पैसे, वो विक्रांत के पास गई, बोला आप मेरे शेयर्स खरीदो और बदले में मुझे पैसे दो, मैं एग्जिट कर जाऊंगी कंपनी से. सानिया उसके बाद will cease to be a shareholder and Vikrant will step into the shoes of Sanya, right? Guys, let's not get confused with IPO. We'll come to IPO in a separate class, but IPO basically, yes, you're right, it's somewhat similar to share subscription, but there's a entire market where purchase between the existing shareholders and public also happens. So that's a different concept. We'll deal with that later. Okay, so now once we know what the basics are, what SSA and SPA is about, we will move on to what the various laws are. And don't worry, anyone who has not understood the difference between SSA and SPA, it will become clearer to you once we go through the entire legal regime which is there under FEMA and Companies Act pertaining to the entire SSA and SPA. Okay, now the thing is, does anyone have any idea as to what the various sections of Companies Act are pertaining to a share purchase? Anyone? Okay, so there's a section called Section 56 Companies Act ke under mein, and that section basically talks about transfer of shares from one shareholder to the other. Now, this particular section, which is Section 56, basically mentions certain steps that are required to be undertaken before one can say that the shares are transferred from one shareholder to the other. Just repeating this entire thing in Hindi for people who are more comfortable with Hindi. Section 56 Companies Act के अंडर में mention करता है that what steps क्या हैं जो कि एक shareholder को लेने हैं before the shareholder can purchase the shares from the other shareholder. So before we get into the entire steps, one very basic concept is that what really is the proof of the ownership of shares in a company. Can anyone, does anyone have any idea? So let's say if you want to be called a shareholder and someone wants you to produce a proof. Absolutely, very nice. Big clap for everyone who has answered share certificate. Absolutely. So share certificate is one of the primary proofs of your shareholding in a company. But that is when the shares of the company are in physical form. Do you know that the shares of a company can also be in dematerialized form? Right. So I can see some responses. Some people know that it can be in demat form as well. So when it's a demat form, then you're not issued a share certificate. In such a scenario, you will be, so there's this entire process where the transferor, the transferring shareholder and the shareholder which is receiving the share, both of them are required to have a demat account with the depository participant. Think of it just like a money transfer which happens online. Similarly, there are two accounts which are maintained with the DP, the depository participant. And once the shares are transferred from the account of the transferor to the transferee, there is a depository slip which is issued to the transferee. That becomes a equivalent of your share certificate. So that over there in case of DMAT becomes the proof of your ownership of the shares in the company. Now that is one proof. There is another proof also, which is if not more than equally good as share certificate, which is your entry in the statutory register called as Register of Members. So a company, any company in India under the Companies Act is required to maintain certain statutory registers mandatorily, one of them being Register of Members. So, right, absolutely. Someone has quoted the section also, section 88. So under that section, any shareholder who purchases the share of the company, his or her name is required to be entered in the Register of Members, and a person who ceases to be a shareholder of the company, basically the transferring shareholder, his or her name is required to be removed from the Register of Members. Now, these are the 2-3 things which basically are required to be undertaken under section 56 of the Companies Act, read with 88, before one can say that the entire transfer is complete. As I said, the step one would be that whenever, let's say, Sania and Vikrant want to exchange shares. Sania wants to sell, Vikrant wants to purchase the shares. So what will happen in terms of the process in the company is that Sania and Vikrant will execute a share transfer form. This is called as Form SH4 under the Companies Act. They will within themselves sign it. This form is a very basic form. The format is mentioned under the Companies Act itself, where the details of both the parties are mentioned, the number of shares that are being transferred, that is mentioned, the consideration is mentioned, and then there is a stamp duty which differs from state to state, that is also paid over there on the stamp on the share transfer form. Once that is done, the executed share transfer form SH4, which is signed by both the parties, is given by the parties to the board of the company. Once the board of the company receives this particular form, they take it on record. Basically, they approve it. And once that happens, that is when the transfer of the money happens, and the share certificates, which were currently issued in the name of Sania, is basically cancelled. And on the back of the share certificate, the name of the new shareholder, which is Vikrant, is mentioned. Or in case of a DMAT transfer, Sania will give instructions to her depository participant to transfer the shares from her account to Vikrant. Once that happens, then the company is under a duty to enter the name of Vikrant in the Register of Members maintained by it, and is also liable to strike down Sania's name from the Register of Members. Once this process is complete is exactly when you say that the transfer of the shares between Sania and Vikrant is completed and concluded. Is the entire process clear to everyone? Perfect. I see one very pertinent question that someone has asked as to whether this SPA would be between only the purchaser and seller or also between the company. Now, SPA is, of course, just like any other contract. Contractually, it is possible that it is only between the seller and the purchaser. But as we go through the entire class and as you learn more about the SPA, you will understand that there are a lot of representations and warranties which are given about the current status of the company, which is the reason why you would see that most of the times the company is made a confirming party, where the company also confirms that yes, whatever is mentioned about the company is correct, especially when the selling party is a promoter. So yes, it's possible to have an SPA where only the seller and the purchaser are parties, or also where the company is a confirming party. I think that doubt is clear. Someone is asking about DMAT and depository slip part. I'll quickly re-explain this. So basically, when you are doing the transfer of shares through a DMAT way, what happens is that Sania, who is the existing shareholder, will be giving an instruction to her depository participant, and the depository participant will then transfer the shares held by Sania in her account to Vikrant's account. And once that happens is when you say the transfer has officially happened. Yeah, someone is also asking, when is the share purchase agreement executed? So guys, we will come to that, but all of this process that I just explained to you, that happens only after you have already signed the SPA. We will come to that part very shortly and your doubts will be cleared. Right now, we are just discussing what the laws pertaining to share purchase and share subscription are under the Companies Act. Someone is also asking if register of members is maintained with ROC or with the company. So the register of members is maintained with the company. It's not filed with the ROC. There are 5 or 6 statutory registers that every company is required to maintain. Think of it like a register that you maintain, which reflects the current status of the company. One of them being register of members. So this was the law pertaining to the share purchase. Someone is asking how Sanya will tell the depository participant to transfer share to Vikrant's account. See, guys, think of it this way. Sanya and Vikrant both are supposed to hold accounts with the depository participants. Let's go to the basics. If someone wants to transfer money to you, you can't have the money if you don't have a bank account, right? So if you have a bank account and the other side also has a bank account, is when that person can transfer money from his account to your account. Similarly, if two shareholders or if transferring shareholder and an investor want to have the share transfer in a demat form, both the parties are required to have demat accounts. So when both the parties are holding demat accounts, then the transferor will give instructions to his or her depository participant to transfer the shares from her or his demat account to the demat account of the transferee. So this is how it is concluded. Okay, moving on. So this is under the Companies Act. Now, typically, in most cases, the share transfer happens between two residents. If it's between two residents, and when I say residents would mean two shareholders who are based out of India. But it's also possible that one of the shareholders is a non-resident and is staying outside India. When that happens, then the entire regime of transfer becomes a little bit more complicated. And then you are required to also follow certain procedural guidelines or law, which is mentioned under the Foreign Exchange Management Act. So just to give you a small brief as to what FEMA is, Foreign Exchange Management Act basically governs the inflow and outflow of money from and to India. So whenever money is coming from abroad, or if the money is leaving India and going abroad, we have a regulator called Reserve Bank of India, which basically governs the entire regime. This act is basically called Foreign Exchange Management Act 1999. This act has a lot of guidelines, sub-regulations, which govern a lot of things. But when we talk about an SSA and an SPA, then we are talking about this particular rule called as FEMA non-debt instruments rule. When you talk about a transfer which is happening between a resident and a non-resident, I'm going to tell you one very nice trick which is really going to help you understand things. Okay, so when the money is coming into India, obviously we are benefiting, right? Because India is getting more foreign exchange. So when the money is coming into India from abroad, RBI is a little bit more relaxed. When the money is leaving India, when the money is going from India to abroad, that is when RBI acts a little more stringent, and the regulations try to regulate it a bit more, because of course your own currency is leaving and going abroad. Once you understand this basic, most of the regulations or most of the requirements that are mentioned in the non-debt instruments rule become much easier for you. Now, taking cue from there, let's take a situation where Sanya is a resident shareholder who's currently holding shares into India, into an Indian company. And let's say Kunal, who is a non-resident Indian, wants to purchase the shares from Sanya, who's residing in India. Now, when this happens, the transfer is happening from Sanya, who's staying in India, to Kunal, which means the money will be coming from Kunal to Sanya, right? Because Sanya is transferring her shares, so she is eligible to get money from Kunal, which means the money is coming from abroad to India. When that happens, then FEMA says that minimum for the share exchange, minimum of the fair market valuation is required to be paid by Kunal to Sanya. I'll make it much simple for you. So when Sanya and Kunal are both in India, they can actually purchase shares at 10 rupees also, or at 20 rupees also. Like, it can be as less as possible. But when Sanya is a resident and Kunal is a non-resident, there is a certain basic limit below which this entire transaction cannot happen. Now, what is a fair market valuation? Fair market valuation is basically a process where there's a registered valuer who comes and values the company and bases the operations of the company, the way the company's liabilities are, the amount of debt the company has taken, the amount of operations that company has expanded, taking everything into mind, and the kind of projections that the company has, like, in the next 10 years or in the next 5 years, the company plans to do X 10 things or 5 things. Taking all of these into consideration, a registered valuer values the company and says that, okay, as per my valuation, the company's equity shareholding should at least be 100 rupees or 120 rupees per share. Think of it this way, that for land, there is a circle rate, right? I'm sure everyone knows about this. Everyone over here must have purchased some land at some point in time, or must have been involved in some land purchase. So whenever you're purchasing a land, there's a circle rate, right? Which says that, okay, this is the market rate that is going on of the land. This fair market valuation is exactly like that. It basically values the company relatively in the market and tells you that this is what the per equity price of the company should be. Now, before a share transfer happens between a resident and a non-resident, this fair market valuation is required to be done. It's a prerequisite. Once that is done, then, as I was telling you, since Sanya, being a resident, is selling the shares to Kunal, who's a non-resident, the money is coming from Bahar. If the fair market valuation, for instance, comes to 120, Kunal has to at least give 120 rupees to Sanya. It can go above. It can be 140, it can be 160, it can be 180, but it can't be 119. It has to be at least 120. So this is one of the rules. Now let's take the reverse. When, let's say, the exchange is happening from a non-resident to resident. So let's say Kunal is currently a shareholder of the company. He is a non-resident staying abroad. Sanya is a new investor who is basically a resident of India, and she wants to purchase the shares. In this case, what will happen is that since the transfer is going to happen from Kunal, who's a non-resident, to Sanya, who's a resident, the money is flowing from Sanya, who's a resident, to Kunal, who's a non-resident. Over there, if you see, the money is flowing abroad, right? It's going into the pockets of someone who's sitting abroad. In this case, it's the reverse rule. The money, the entire transaction cannot happen at a money which is more than 120. It can be 119, 18, it can be 10 rupees, but it can't be 121. So is everyone clear about the entire rule around fair market valuation? Cool. Fair market valuation, as I was explaining you, that's there are various methods given under the FEMA, under the non-debt instruments rule. Any registered valuer, any independent chartered accountant, or a merchant banker can do this valuation. And there are various ways. Any internationally accepted methodology can be used. When we go through the masterclass on FEMA, we will go through all of this in detail. Someone has asked why this difference. I just explained it. I'll reiterate it for your benefit. The entire, the FEMA, the basic of FEMA is basically to increase as much foreign exchange influx into India and to control the outflow of Indian currency abroad. So this is the entire rationale as to why we have this entire fair market valuation difference when it is a transaction happening from non-resident to resident or from resident to non-resident. We can go through this entire rule once again when we go through the FEMA masterclass. Coming back, so this is one of the basics that is required under FEMA for a transfer. The second, as I just saw someone very rightly pointed out about FCTRS. Now, FCTRS is basically a filing which is basically required to be, it's a very basic filing where again you are required to mention the transferring shareholder, the transferor shareholder, the entire consideration, the number of shares transferred. And then this entire form is filed on the online portal. It's called Firms. This is a way of RBI keeping a tab of what all shares are transferred between non-resident and resident. Think of it. If this form is not there, how will the RBI get to know that some transactions happen between a non-resident and resident? They will not get to know unless there is some form of filing that is required to be done with them. So just to keep a tab of all the transactions that are happening between a resident and non-resident, this form is required to be filed within 60 days of the transfer between the transferor and the transferee. So far, so good. If there's any question, you can shoot it down in the chat box. All right. So perfect. I think now we have the basic idea of how a transfer works and what are the basic laws that you are required to know whenever you are contemplating a transfer of share between two shareholders. Oh, someone has a beautiful question. Someone is asking, what is the role of a lawyer in this? The role of a lawyer essentially over here is negotiating the entire share purchase agreement. And trust me on this, once we finish the entire masterclass, you will understand this entire transaction cannot happen without a lawyer getting involved. We'll come to that. Just have some patience. It's going to be super interesting, but we want to come to that. Okay, now coming to the laws that you have to know when you are doing a share subscription. Reminding you again, a share subscription is when fresh new shares are being issued by the company to an investor, wherein the company is wherein the money is not going to any existing shareholder, but it is coming to the company, right? So anyone has any idea of what are the relevant sections under the Companies Act pertaining to share issuance? 58 is not right. Anyone else? 43 is close enough. Anyone else? 56 we already talked about. No. Okay. So the two sections which are really important under the Companies Act that you have to read as a Bible before you do a share subscription is section 62 and section 42. Section 62 contemplates two different ways in which share subscription can happen. One is a rights issue under section 62 1A, and the second is preferential allotment under section 62 1C. Anyone has any idea as to what a rights issue is? It's the most basic form in which a company issues shares to people. IPO is not the right answer, but okay, let me explain this. When you say rights issue, absolutely, Hardeep, thank you so much. It's issuance of shares to existing shareholders. So, bilkul simple tarike se we'll understand. It says rights issue. Why is it called rights issue? Has anyone ever thought this? So, the reason why it's called rights issue is because when you're already holding a share, it's like a privilege or a right that you have that whenever a company wants to issue shares, you would be given the right to be issued shares before a third party, which is not a current shareholder, is offered shares. So rights issue under 62(1)(a) is a process where, let's say, the company wants some money and it goes to its current shareholders and says that, you know, I need money. You guys are already there. You guys know our company. You guys know all the process. And since you already know, I don't think there is any DD required. And you can just subscribe to more shares. I will give you, for example, if let's say Vikrant is holding 5% shares, Yashasvi is holding 10% shares, Kunal is holding 15% shares, then in the same ratio, more shares are issued to each of them. They give the money to the company, and without any hustle, without any DD, without spending any money on investment banker, the company gets the gets more money, and in turn the current shareholders have the same shareholding that they were holding maintained in the company. This is a mode that is chosen by a company when they are not looking for a very big investment, and they basically want they are sure that the existing shareholders will be able to give in that much of money. Now, it's only when the amount of money required by the company is quite a lot, and the company or the promoters think that the current shareholders may not be able to give as much money, is when you don't take the rights issue mode and you go out and seek a third party investor who's not currently a shareholder. Now, as I said in the beginning, rights issue is basically more, think of it like a right that the current shareholder has to be issued more shares. Now, what happens when, let's say, the company was confident that, okay, I can raise money through rights issue because I don't need more than, let's say, 50 lakhs. But the company goes to the rights issue shareholders and the current shareholders, and they are not ready. Some of them are not ready to purchase shares. So let's say there are 5 shareholders. There's Shweta, there's Yashasvi, there's Kunal, there's Mridul, there's Srinivas. The company goes and asks all of them that, listen, I need money. Can you just give me money? I'll give you more shares to you to maintain your shareholding. Sanya, Kunal, Srinivas, and Mridul are okay with it. But let's say Shweta does not want to be issued the shares, and she's like, I don't have money to give you any more money to give you. So why don't you go ahead and raise the money from the rest of the shareholders? So what will happen in this situation is that let's say company was going to offer Shweta 10 shares, and Shweta said a no. Company will then go back to all the remaining shareholders and will then offer them more shares in the same ratio as their holding shares. So let's say if Sanya is holding 5 shares, then 5% shares and 5% of 10 shares will be offered to Sanya. Kunal is holding 15% shares, then 15% of 10 is what will be offered to Kunal. So that again, the money, the same amount of money that company wanted to raise is raised from the existing shareholders only. Now, there can also be a situation where none of the shareholders want to give in money. They're like, we don't have money. We don't want to give you any money. What does the company do then? In such a situation, the company may then go out and issue the same amount of shares to the third party shareholder. Now, the very basic reason why a company would want to prefer a rights issue over a preferential allotment is because, number one, it saves a lot of cost, because you are not giving any money to investment banker. It saves a lot of hassle because there is no DD. Third and foremost, there is no fair market valuation required, and the shares can be issued at even rupees 10. Again, this is only when the issuance is happening to a resident shareholder. The moment there's a non-resident shareholder, the same process that I just explained to you for under the FEMA for a non-resident resident shareholder transaction, that same thing applies here. Now, over here, how you will see it as that think of it this way. Over there, you were imagining Sanya as a resident shareholder and Kunal as a non-resident shareholder. Over here, just replace the transferring shareholder with company. The company over here is a resident. So when the company is issuing shares to a non-resident shareholder, it becomes think of it like an issuance from a resident to a non-resident, and hence the money flowing from non-resident to resident, in which case minimum FMB is to be maintained. So now we know what a rights issue is. Let's say we are going to raise a lot of money. How do we do that? We find out the third party shareholder, and then we do it under section 62(1)(c), which is preferential allotment. Now, preferential allotment is a process which is a little more tedious. It's a little more complex. And there are a lot of rules, like, again, you have to follow valuation. There is a special account that is required to be opened, and the money that is raised from that entire preferential allotment has to come in that particular account only. And then there are a couple of other rules, like, return of allotment has to be filed. It's called PAS 3, that is filed with the registrar of companies. Again, since this is a new issuance, a fresh share certificate is issued. There is a permission that is required from the current shareholders of the company. That happens in your extraordinary general meeting. Yes, Srinivas, absolutely. I just noticed it. So shareholders resolution is also required, where more than 75% of the shareholders are giving consent to this entire transaction happening. So this is how these are the various steps that happen under your Companies Act. Any questions so far on the process? Yeah, so Kunal, the benefits of rights, see, first of all, understand this. When a lot of money is required for the operations of the company, in most cases, rights issue is not the answer, because the current shareholders may not give you as much money. So you will opt for a rights issue only when the money that you are going to raise is much lesser in quantum. Once that is set, then rights issue basically gives you a couple of benefits. Like, for example, there is no investment banker required, right? Like how when a company needs money, they hire an investment banker who goes out and then finds an investor. That is not required to be done. The DD process does not happen, because DD is a process where the company has to produce all its old data, has to give all its licenses, clean everything. So that process is not required to be done. And if it's a resident to resident transaction, then no valuation is required. While in case of a preferential allotment, even if the issuance is happening to a resident, a fair market valuation is required to be done. So these are the various benefits of having a rights issue. Someone is asking, so no lawyer needed in rights issue. You do need a lawyer for drafting of all these basic documents, but that can also be done by the company secretary of the company. So yes, in case of rights issue, the role of lawyer is a bit limited than when you talk about a preferential allotment. And most importantly, when you're talking about a transaction document, which is a share purchase agreement, or in this case, a share subscription agreement. In case of rights issue, it's not required. That is mostly signed in case of a preferential allotment, which is with a third party shareholder who's not a part of the company. Are we clear on this? Preferential allotment is basically a process where you are issuing shares to a third party, to a person who's currently not a shareholder of the company. And because that person is not a shareholder of the company is the reason why that company would want you to enter into an SPA, wherein the company and the promoter give certain promises to that new investor, saying that, okay, my company has these licenses, we are compliant with law. All of those things are required to be noted down in the SPA. Yes, it's a special resolution that is required to be passed in the EGM of the company for passing a preferential allotment. And now coming back to FEMA, just like how I explained for share transfer, again, as I said, fair market valuation is required. And here another form called as form FCGPR is required to be filed within 30 days of the issuance. In terms of process, just to quickly give you a chronological order, what would happen is that first of all, the particular shareholder is identified. Once the shareholder is identified, then there is a form called as Form PAS4. It's called as Private Placement Offer Letter. It's as simple as this document is a little bit elaborate, but it's a very simple document. The entire format is given again under Companies Act. Over here, what will happen is that the company will mention the details of the offer. Like, for example, the name of the investor, the number of shares being issued, the price of the share, the current status of the company, and the financial statement of the company, the profit and loss statement. Everything is mentioned on the passport. That is then issued. So that is filled out. After that, the company then goes through a board meeting. In the board meeting, that draft private placement offer letter is put on record. The board of the directors discuss it and say that, okay, this is identified investor. We want to issue shares to this particular investor. Here is the draft private placement offer letter that we are going to issue to the shareholder. And since a special resolution is required to be passed before we issue this, here are we going to call the EGM of the company. After this, the EGM of the company is held. In the EGM, the draft private placement offer letter is put before the shareholders. They approve the draft, and after they do, they approve issuance of shares to the third party shareholder. After the meeting is concluded, the PAS4 is issued to the third party investor. The third party investor sees it, signs it, sends it back to us, to the company. Once that happens, then a date is set when the entire money is transferred from the third party shareholder to the company account. It's a special account which is designated only for this purpose. Once that happens, then the company issues share certificates to the new shareholder, enters the name of the shareholder in the register of members. Once this is done, a proof or a copy of the register of members along with the share certificate is given to the shareholder, and that becomes a valid proof of the transfer and the ownership of the share by the third party investor into the company. So this is the entire process from top to bottom. Any questions over here? Someone is asking, can a transaction have a mixture of rights issue and preferential allotment? But my question is, why would you do that? Because if you are already doing a preferential allotment, I mean, if you want to raise money by both the methods, you can do that. You can first finish your rights issue, and then you can go to the private placement process. Please explain the steps again. Okay, I'll quickly recap it for you. Essentially, there's a board meeting that happens. In the board meeting, the board of the company discusses and approves the draft offer letter, which is a form PAS4. Once the PAS4 is approved, they call for an EGM. In the EGM, the shareholders again pass a special resolution saying that we are fine with the shares being issued to this new investor, and we are fine with this draft PAS4 being issued to the new investor. After that, the PAS4 is issued to the investor. The investor sees it, signs it, sends it to the company. The company then gives the account details and all to the investor. The investor transfers the money to this account. Once the account money hits the account, the company gives a share certificate as a proof of ownership to the shareholder, enters the name of the shareholder in this statutory register of members, give an extract or a copy of it to the shareholder. Once that's done, the entire process is complete. In case the issuance is happening to a non-resident investor, then the form FCGPR is required to be filed with the RBI within 30 days of the transfer. I think the process is clear to you all. Now, someone is asking extraordinary general, what is it? Extraordinary general meeting is basically a meeting where the shareholders of the company come together and approve or reject various decisions of the company. Now, under the Companies Act, there are various matters that cannot be passed only at the board level. It can be passed only when the shareholders of the company are also approving it. Some matters require a consent by 50% of the shareholders, and some matters require the consent of at least 75% of the shareholders. So that is what the entire functionality of a general meeting is. General meeting can be an annual general meeting or an extraordinary general meeting. We will talk about all of this in separate classes. We will learn the nuances in proper separate classes. Now coming back to the SSA and SPA, we know the basic laws under FEMA and Companies Act. I'll quickly recap the sections so that you guys can go back and read it, so that when in the next class, when we talk about various clauses of SSA and SPA, you guys already masters of the law. You can note it down. Under Companies Act, for transfer, you should know section 56. Under Companies Act, for share subscription, you should know section 62(1)(a, section 62(1)(c, and section 42. And for under the FEMA, there is this entire regulation called as Foreign Exchange Management Non-Debt Instruments Rules, which is what you have to read for the entire process on share subscription and share purchase. Apart from this, in terms of law, you of course need to know the basics of the Contract Act before we move on to learning the clauses of SSA and SPA. The very basic concepts such as your representations, warranties, covenants, indemnity, damages, all of this as concepts you would need to know. Now, these concepts are very intertwined with the clauses that we will be discussing in SPA or SSA. We will take these each of these concepts one by one in the next class when we are discussing various clauses. With that, I think we can close the entire class on SSA and SPA. I am ready to take questions now, whatever questions you have on SSA and SPA. I'll repeat the sections. These are sections 56, 62(1)(a, 62(1)(c of the Companies Act. And under FEMA, it is the FEMA Non-Debt Instruments Rule. I am ready to take any questions that you guys have on all of these provisions, whatever we learned today.
Guys, you can ask a question in chat box.
Someone is asking role of valuation of company in FEMA provisions. So if you talk about the valuation when it comes to share purchase, as I was telling you, section 56 does not require any valuation. So if it's a transaction between resident to resident, the FEMA does not apply. Only Companies Act applies. So which is the reason why you do not require any valuation. But when the transaction is happening from a resident to a non-resident or a non-resident to resident, the moment there is a non-resident involved, FEMA applies, and which is why under FEMA, valuation is required to be done. When it comes to a share subscription, the same thing. If the issuance is happening to a resident, FEMA does not apply. But however, in this case, under the Companies Act also, if the issuance is happening to non-resident or a resident by way of preferential allotment, under section 62(1)(c, read with 42, you still require a valuation. So that is a slight difference when it comes to SSA and SPA. Thank you so much, Nikita. Someone is asking, when a company seeks money from new subscribers, isn't SEBI involved? So guys, SEBI is a regulator which is only attracted when the transaction is happening in the regime of a public company, a public listed company. So when any transfer or any issuance is happening of the shares of a listed entity is when SEBI is involved. We will have a proper class on SEBI regulations also when we'll talk about IPO and everything. But yes, when you're talking about private companies, SEBI is not involved. FEMA non-debt instrument rules. Thank you so much, Anamika. Is preferential issue similar to SSA? Absolutely. So okay, SSA and SPA guys are these are the procedural documents. Just think of it as a document where, okay, when you want to do something, do you not make to-do list for yourself? You make to-do list saying, okay, I have to go and purchase vegetables from the market. These are the things that I need to purchase, and this is my budget, and I'll go to the market and I'll purchase it. That's exactly what SSA and SPA is for you. When someone wants to purchase shares, they list out all the steps that they want to do. They also list out whatever considerations they have, and like whatever they want the shopkeeper, or for in this case the company or the shareholder, the transferring shareholder, to adhere to. So it's as simple as that. So yes, when you are doing a preferential allotment, which is basically where you are getting issued shares in the company, or where you are subscribing shares in the company, you enter into an SSA. Someone is asking SSA and SPA, which one requires shareholders meeting? So when I talked about share purchase, not even once did I say that you need a shareholders resolution. Section 56 only requires a board meeting, nothing else. So which is the reason why in case of a transfer of shares between two entities, there is no shareholders meeting required. And that is why in case of SPA, which is a transaction document pertaining to transfer of shares from the existing shareholder to a new shareholder, you don't need to mention, or you don't need to worry anything about the general meeting or the EGM or the shareholders resolution. It's only in case of an SSA which mentions preferential allotment that you need a shareholders resolution. Yeah. Ekansh, I think they're asking when would the next class be. So I think we'll discuss it and we'll let you know the schedule shortly.
Guys,
we
you
will
will
send
get
a schedule in the
notification.
Discord group.
Guys, you will get the notification
Class.
whenever the next class is.
Someone was asking, is there any separate rules for preferential allotment for listed companies? You do have. It's called SEBI LODR regulations. We will have a proper class on listed entity regulations where we'll discuss all of these things in light of the SEBI LODR regulations. Steps when SPA. So a lot of these concepts, guys, in the next class, when we're talking about various clauses, we'll reiterate it. We'll go through that again. Any more questions?
Any more concept related questions?
Sorry, procedure that you mentioned for PAS4 is for section 42 or 62. Okay, so section 62 is basically the charging section. That's the section under which you do a preferential allotment. But when you are doing a preferential allotment, you are also required to follow the process which is set out under section 42 private placement. So you have to read these two sections in conjunction. Whenever you are doing a share issuance by way of preferential allotment under section 62(1)(c), you have to follow the process under section 42 as well. So these go hand in hand. Yeah, someone is saying you'll discuss at the end of the class about the role of a lawyer. I thought I'll get time to discuss that, but I mean, I thought that maybe we can do this once we start the clauses of the SPA. But let me quickly tell you in a nutshell what the role of the lawyer over here would be. In a typical private equity or an M&A transaction, the first stage is the term sheet stage. Term sheet is like an abridged version of an agreement where you basically set out what the basic terms of your transaction is going to be. Over there, the drafting is done by the lawyer. Now, once that happens, then as I told you in the beginning, the due diligence on the company begins. Due diligence is also done by the lawyers who represent the investors. It's a very detailed process that happens over a span of anywhere between 2 to 6 weeks or longer or shorter, depending upon the requirement. That is done by the lawyers representing the investor. Once that happens, and when the lawyers reach the stage of documentation, the drafting is done mostly by the drafting of the SSA or SPA is done mostly by the lawyers representing the investors. Once they draft it, then they send it to the lawyers representing the company or the selling shareholder or the promoter, and the company's lawyers or the selling shareholders lawyers then go through the SSA and SPA. They obviously, then it's a fight, it's a proper negotiation which happens where both the parties try and bring the provisions tilted towards them. Once that entire process is done, then all of these other documents, like for example, in case of share transfer, execution of the share transfer forms, or in case of a share issuance, the issuance of the private placement offer letter, all of that is done by the lawyers. Himani, DD, on DD, I think we'll have a proper class again, because DD is something that is a very elaborate process, and we'll go through all the nuances and chapters of DD separately. Thank you so much. Is the issue of rights in private placement same? No, as I explained, rights issue is separate and private placement is separate. Rights issue happens to the existing shareholders of the company, and private placement happens to any new investor. Someone is asking, what is ICDR? See, ICDR is again a SEBI regulation which only governs the issuance of shares of a listed company. So we will deal with that in a separate class. Someone is asking, how much does a lawyer earn for doing this kind of work? There's no clear answer on this. It totally depends on the nature of the transaction and the kind of expertise that the lawyer has. So yeah. Yeah, Pankaj, please go ahead. What's your doubt? No, a lawyer can't really be a plain registered lawyer, valuer. If you check Companies Act, there's a definition of registered valuer mentioned under the Companies Act. There's a proper exam that is required to be qualified for a person to be called a registered valuer, and typically these are CAs. Any more concept-based questions, or we can just call it a day?
Any more questions related to the concept, guys, or?
Sorry, Kunal, you've been asking this again. Can you explain the 120 example? I'm not sure if I follow your question. Are you asking about the FMB related example? Okay, got it. Okay, I'll just quickly re-explain this. So as I was telling you, the entire crux of FEMA is that when the money is coming from abroad to India, the RBI is a bit relaxed. When the coming is going from India to abroad, RBI tries to control it as much as possible. So taking a cue from there, let's say the fair market valuation of the company comes to 120. Okay. Now let's say Kunal is a non-resident, Sanya is a resident. Sanya is holding the shares in the company right now, and Sanya wants to sell her shares to Kunal. So naturally, when Sanya is selling the shares, Kunal will be the one who will be sending the money to Sanya, which means money is coming from abroad to India, in which case RBI would want as much money as possible to come. So the law says that minimum 120, which is a fair market valuation, has to be given to Sanya by Kunal, who's a non-resident. It can be more than that. It can be 120, 140, 160, but it cannot be 190. It has to be 120. The idea behind this is to garner as much of foreign exchange in India as possible. The reverse will happen when the money is flowing from Sanya to Kunal, where not more than 120 can be given from Sanya, who is sitting in India, to Kunal, who's sitting abroad. So it can be 119, 118, 10 rupees also, but it can't be 120. I think, Ikansh, we're done with the questions for today.
Okay, ma'am.
Yeah.
Thank you, ma'am, for the wonderful session.
Thank you so much. I had a great time.
You
Teaching all of
explained
you.
the concept like really well. I
Thank you
also
so
liked
much.
it.
Thank you. See you all. Thank you. See you in the next session. Bye.
Bye, ma'am. Good night.
Good night. Bye.
Like you get the notification today or yesterday, you will get the notification again when will be the masterclass happen. I'm not sure about the recordings. Recordings will be uploaded, but I'm not sure. You will get the notification. They will notify you when will be the recordings be uploaded and on what courses it will be uploaded. So Takshi, it would have created a lot of chaos if we have allowed you to speak, because there were many questions and the chat box was regulated properly. Yeah, Santosh, you can leave the session.